brilliant. I've just took a screenshot of that just so we have the results of that. Bear with me 1 second. Brilliant. So a couple of things for those of you that have never used Zoom before. We cannot see and we cannot hear you. There are only two ways that you can communicate with us today, and that is via the chat function at the bottom of your screen and the QEA. What I would just say is with the Q&A, if you could just leave it till the end of the speakers, just so they can get through the Q&A effectively and get through as many questions as they possibly can. If you do have any issues or there are things that you're unsure about, please don't hesitate to contact me. I will be in the chat box and I'll be able to answer any questions there. So, welcome to the webinar. Our webinar today is Managing Your People Through COVID-19 and the Laws and Logistics and the Essentials. And today I'm joined by Karen Coleman and Sarah Plant. And I'm just going to stop sharing my screen just now so that Sarah and Karen can get started. And it's over to you, ladies.
Thank you very much, Laura. Hi, everyone. It feels very strange talking to people that I can't see, so bear with us a little bit. That Menti screen was quite interesting, actually. So a lot of you are clearly dealing with furloughed employees and people working from home. I suspect that some of you are probably thinking more about furloughing, hence why you're here today. So hopefully we can cover some of the key aspects. Karen's going to be popping up a presentation for us in a minute that we're going to start working through. But just to introduce myself and Karen a little bit as well. So Karen is a employment law solicitor with Excello Law. She is my go-to employment law solicitor because she is very pragmatic in her advice and she tells it how it is, which is very helpful for a HR consultant because I need to be able to rely on that to give my clients peace of mind as well. And as an HR consultant, that's really, really important to me to make sure that the businesses can react to that information correctly, and I can sleep at night as well. Karen's actually going to start the presentation. Are you able to put it up on the screen, Karen? It's not shared at the moment. And we'll just work through the key elements of today's session. Thank you, Karen. I think it's coming up. There we go. So these are our key topics. I'm not going to read through every single one because I'm quite sure that you're capable to do so, but we're going to go into some detail around the coronavirus job retention scheme, what it is, how you get to it, what you need to be putting in your furlough agreements, later on talking a little bit about redundancies and the engagement of employees, both in furlough, working from home and still in the workplace actually. That's quite a lot to cover and we've only got 40 minutes and we have got some additional things that we want to try and cover as well. So we're just going to get cracking and hopefully we can cover as much for you as possible. So I'll hand over to Karen. Thank you.
Okay, thank you very much, Sarah. Okay, if you could all please bear with me then. So this is my first go at the webinar and the screen share, so I think I know what I'm doing. I know I look like a bit like I'm in heaven at the minute because of my background, which I can tell you the last 4 weeks has not been heaven. But well, I'll get straight into it. The slides are quite a minimum and I've done this deliberately because you'll all know that it's just been a moving feast over the last 4 weeks. So we have got some slides. In terms of my section, which is largely the job retention scheme, I'm actually going to be using these links to go to the guidance itself. So the coronavirus job retention scheme, I'm very quickly going to change how I call that to the furlough scheme, was first announced by the Chancellor on the 20th of March. We had 4 lines on the government website about that were put up on the 21st of March about the screen. I had a number of clients furloughing that week. I've probably got about 15 to 20 clients that are furloughed staff now. Most of them did it in that week and we had those 4 lines to go from. We then, on the 26th of April, got this guidance. So this is the link to the current guidance. So you'll see there, sorry, 26th of March. It was published on the 26th of March. And you'll see there that it was last updated yesterday. So I want to click on this screen because this shows all of the updates to this guidance. So from the 26th of March, when it was published, we've had all of these different changes. And they haven't just been little changes. Sometimes they've been quite significant changes. So I want to talk you through where we are at them right now, based on the current guidance. If, however, this slightly differs from things that you've heard in the past, then it will probably be because we've had these different versions. So I'll go back to the top of the screen. So what we also have now, sorry, I'll just go back to my presentation, is as well as those 5 or 6 versions of the guidance, we also have this Treasury direction. Now, it's a bit of an unusual term, a Treasury direction, but we would all know that legislation is normally passed by an act or by statutory instrument. What this Treasury direction did, and I click on it, is because everything is moving so quickly, there was the Coronavirus Act 2020, and under that act, it gave powers to the Treasury to make directions. So this is the direction they've made. So effectively, even though it's called a direction, this is the law. So this was only issued on the 15th of April last week. And unfortunately, it differs slightly in some key areas, which I'll mention, to what the guidance did say and what the guidance has said. So I'll talk about how we try and deal with those inconsistencies as we go through. So just generally then, what is the scheme? We do have a limited time, so I'm going to cover the key points. Anything that's not covered and that is of importance to them, please do ask in the Q&A and we'll come to those at the end. So it's a temporary scheme to help to provide a grant to employers to help them pay their staff. It was announced it's to cover the period between the 1st of March 2020 and now, as of last Friday, it's been extended until the 30th of June. So it covers 80% of wages of workers unable to work due to the virus. So why is it important to understand the terms of the scheme and the direction? So I wanted to highlight this because this has been expanded in the latest versions of the guidance. This reference to fraud. So it's going to be, the portal is up and running, as you probably know, yesterday to make claims. And it's a relatively straightforward process, as I understand it, to make the claim, and you will then get the money. However, HMRC will have the ability to audit your claims after that, and that's when the detail will come into it. So it says here, HMRC will check claims made through the scheme, and payments may be withheld or need to be repaid. And of particular interest was this part here. HMRC has put in place an online portal for employees and the public to report suspected fraud on the scheme. So that's why it's particularly important to understand the rules of the scheme. And also I do think criminal prosecutions will follow from this in due course. So starting point then, what employers are eligible? So you need to have created a UK PAYE scheme on or before the 19th of March 2020. It says you need to have enrolled for PAYE online. If you weren't enrolled for PAYE online, you can still do so. And it talks about all employers being eligible. Now, also in the guidance, however, is this bit that relates to public sector organisations that says that where employers receive public funding for staff costs, the government is expecting employers to use that money to continue to pay staff in the usual fashion and not furlough them. And this also applies to non-public sector employers who receive public funding for staff costs. So I've got a charity client, for instance, who receives most of their funding through the old Supporting People funding. So this guidance suggests that they're not eligible, that they're not able to claim, and that particular section of the guidance has been there all along. However, that's not in the Treasury direction. There isn't that caveat in there, which does sort of open up the possibility for such employers to make a claim. But to me, the guidance is so clear that I think there must be other repercussions. Maybe perhaps your other funding streams might ask the question. I don't know, but for the time being, I would be advising my such employers to abide by the guidance. Okay, so what employees can be furloughed? So this was a bit of a change last week. Employees who were on your payroll on or before the 19th of March, but also, and this is a sting in the tail, that they were notified to HMRC on an RTI submission on or before the 19th of March 2020. So if you, for example, had an employee that started on, say, the 27th of February, you run a monthly payroll, you put your payroll through on, say, the 25th of February, then that particular employee is not going to have been on an RTI submission on or before the 19th of March. And that currently, as it stands, means that they won't be eligible under the scheme. It also talks about people that were made redundant or stopped working for the employer between the 28th of February and the 19th of March. They can also qualify for the scheme, but they must be re-employed. For people that made redundant, and I think most employers are re-employing those staff, there has been also requests made by people that maybe resigned and left during that period and they can't qualify with their new employer to be put back on their payroll. Certainly the scheme would allow you to do that. I would just say it does mean that they'll be going to be back on your back as an employee, back accruing continuous service and accruing all their rights, including as holiday and things. So I don't think it's quite as simple as maybe the publicity suggested. So what types of employees? We've got normal employees, apprentices on here, agency staff, foreign workers, 0-hour workers, casual workers, fixed term contracts if you extend the contract to cover this period, office holders, which includes directors, which I'm going to come back to briefly in a minute, members of LLP. But it's not just other people that would otherwise have been made redundant, which is what a lot of the initial guidance was saying. It's now very clear that you are able to furlough people just if they have no work or are not working because of coronavirus. So the key people here are people that have been told to shield, so they may have been on unpaid leave because they've been told they've received the formal notification to shield for 12 weeks. So even if you would otherwise have work for them, you're now able to furlough those people. Another key group is carers. So if you've had somebody that's unable to work because the school's off and they've had to look after their children, you are also able to furlough them. Ultimately, it's your decision, but I suspect most employers will do that in that instance. One further thing I wanted to mention was just people that had TUPE transferred after the 19th of March. There seems to be a bit of a grey area in respect of recent TUPE transfers before the 19th of March. And at the moment, it looks like you wouldn't be able to furlough those staff, but certainly TUPE transfers after the 18th of March will be okay. So what is the key thing for all of those employees? And that is this. Employees must not do any work for the employer. So we're looking at the relevant part of the guidance here. An employee cannot undertake work for or on behalf of the organisation. This includes providing services or generating revenue. Therefore, if you have somebody that is doing reduced hours, they cannot be furloughed. So they are effectively doing some work, but not all. And to me, this has been a key failing of the scheme. As I understand it, other jurisdictions have allowed it as a part of a top-up. So, for example, you might only have 50% of work that you could give them, but the government would then enable you to, the government's been topping up, say, the extra 25%. Unfortunately, we are left with this all or nothing situation. I said I would mention briefly directors here. So directors can be furloughed, but the Treasury direction that I mentioned is, to me, in fact, can I go to it? No, I won't go to it. But it talks about the only work that a director can do if they're furloughed is complying with their statutory duties, and specifically talks about filing at Companies House. So, you know, if you've got to file an annual return or change of address or change of director, then that's okay. But anything beyond that, it looks like they will be quite strict about. So, for example, if you are not perhaps maybe generating work, but you are still dealing with your own employees, dealing with their payroll, then to me that isn't meeting that definition. So, what are they paid? So they must be paid not less than. So again, there was no room here to change to pay them less. Not less than 80% of their earnings or salary. So for people on a fixed salary, full or part-time, it's 80% of that amount, but it's capped at £2,500 a month. So effectively, anyone earning over 30,000 a month will get less than the 80%. If the pay varies, it will be either 80% of their So this is if an employee's pay varies from month to month, it is either whichever is the greater of 80% of their average earnings in the 2019-2020 tax year, or what they earn in the equivalent month in the previous year. So for example, when you're calculating what somebody's paid in April, then you consider what they were paid in April 2019 compared to what their average earnings were in the 2019-20 tax year, and whichever is the greater is what they should get paid. So unfortunately, that does mean that every month that amount is going to, that comparison between the two figures needs to be done for those employees. Okay, I'm going to go back to my slides, hopefully. There we go. So I will move on now. Okay, so legal requirements to designate your employee as furloughed. So this is, I'm taking this now from the Treasury direction, which is actually, like I say, the piece of the legislation. So it says an employee is furloughed if the employee has been instructed by the employer to cease all work in relation to their employment. The period for which the employee has ceased or will have ceased is 21 calendar days or more. So that's talking about the 3-week period that we're all aware of now. I should think that the furlough period has to be at least 3 weeks or more. And the instruction is given by reason of circumstances arising as a result of coronavirus or coronavirus disease. Not quite sure what the difference is there, but between the two. But that is the point about not needing to be able to show that that person would otherwise have been made redundant. That to me is quite a wide definition, by reason of circumstances arising as a result of coronavirus. Now, the guidance only referred to notifying employees. So for those employees that had a layoff clause in their contract, then for my clients, we simply did a letter notifying those employees that they were being furloughed and providing the details of the scheme and a few other bits of information. For those who didn't have a layoff clause in their contract, they are not entitled to have their wages reduced below 100%, so we did do agreements for those. The guidance still talks about notifying employees. However, the Treasury direction, which was, like I say, coming last Wednesday, talks about here at 6.7, I've copied, an employee has been instructed by the employer to cease all work in relation to their employment only if the employer and the employee have agreed in writing, which may be in an electronic form such as an email, that the employee will cease all work in relation to their employment. Now, to me, you can't get much clearer than that you're needing to get your employee to agree expressly that they will cease all work in relation to their employment. Now, this has caused quite a stir on the basis that, you know, for the previous 4 weeks, people thought that they didn't need to get it as an agreement. And in fact, there has been another guidance issued on the Friday just gone that was obviously after this, that again talks about only the need to notify and that the employee doesn't need to respond. So where does that leave us practically? For people that have already furloughed, I'm taking the position that if you already furloughed them and it's in writing, you don't need to go back to them and get their agreement. We're going to work on the basis that the guidance has been updated since this Treasury direction, and that it would be, there's barristers saying it must be reasonable for you to rely upon that, and if HMRC then tried to backtrack on that, that you would be able to apply to judicial review of that decision. Clearly nobody wants to be in the position of judicial review, but it certainly seems as a community, sort of a, you know, the employment law community, that's the position we're going to be taking. For anybody now, though, that is furloughing in the future, or maybe needs to extend the period of furlough for the employee in the future, then I would certainly be including in there, in that, doing it as an agreement and including in there that they're expressly confirming that they are agreeing to cease all work. So that brings us nicely on to the content for a furlough agreement. Probably there will be tens of thousands of different ways of the furlough agreement that's been done. For my own, how I'm doing it is providing sort of a brief introduction of the scheme, talking about the Chancellor's announcement and what the scheme provides, including an anticipated length of furlough. Now, I fully accept that you might not necessarily know how long that length furlough is going to be. But I think if you just say sort of till the 30th of June or such other time, then if actually you know that you're hoping to be back sooner than that, then it's better to try and create a reasonable expectation in the employee's mind. So whatever you put, I would always put in the ability to shorten or extend it, but do have a, give a good estimate of what you think will be, and then you can rely upon the ability to shorten and extend. So in that, like I've just said, we'll confirm that the employers must do no work for the employer, set out what they will and will not be paid. So how that 80% is going to be calculated on their salary and wages, i.e. whether their salary and it's fixed or whether it will be the variable calculation, but also what they will not be paid. So the guidance, again, I can't go in too much detail, but it says that regular payments can be continued. So for example, if somebody has a contractual right to certain overtime, that can be included in the calculation, but anything discretionary cannot be included. So if you have a discretionary bonus scheme or discretionary commission, that can't be, well, it could be, you could choose to include it, but you wouldn't be able to reclaim it from HMRC. Similarly, if you provide things like a company car or insurance, then you're not going to be able to reclaim an element of those from the scheme either. So if you are getting the employee to agree and you feel you need to remove those benefits, then that will need to be referred to within this agreement. So next, an up-to-date, an obligation on the employee to provide up-to-date contact details so that you can get hold of them at any time during the furlough period. And then specifically this signature bit there, where I'm asking them now to sign for those three things. So to sign to confirm they've agreed that they're furloughed, that they understand the scheme conditions, and that they will not undertake any work for the employer whilst furloughed. There is a few optional things you could include. If, for example, you provide more than the statutory minimum 28 days holiday or 5.6 weeks holiday, you could retry it. Say, for example, you provided an extra week. You could ask them to agree to limit their accrual during the furlough period such that they might not be getting the extra couple of days. I have seen agreements where if you didn't have a right to lay off in your contract, that you now get the employee to sign a right to lay off in that contract. So for example, if the furlough scheme ended on the 30th of June, but you're not in a position to give them their full-time work back, you might need to lay them off or put them on short time for a little bit after that. So if you don't have that in your contract of employment, you could include that in the agreement. The ability to defer the payment. So if you have payrolls coming up and you don't think, this was a big concern at the start because nobody thought that the HMRC portal would actually be functional by the 20th of April. So people were envisaging that nothing would probably work you wouldn't get your money back for, perhaps a couple of months or something, and employers didn't have the money to cover that off. So there has been the ability to defer payment put in some agreements. I don't like it. I don't think it's good HR practice. And so I've not been putting it in as standards, but just saying to clients, if you really, really don't think you can meet that payroll, then it's something to consider, but I wouldn't put it in as standard. So we know the portal's up and running. They've said that the first payments should start being made at the end of the month. So fingers crossed, in which case nobody will need to rely, or very few people will hopefully need to rely on that ability to defer. Training requirements, an employee can train whilst they're on furlough, and in fact the latest guidance sort of encourages employers to consider training their employees during this period. That training, however, must not generate revenue or provide services for the employer. So for example, if it's an online course, that's going to be fine, they're not doing anything. If you're asking them to maybe draw up a marketing plan for your business for the next 12 months, which actually you're then going to use, then that is providing services. So but most clients that I've got, they are using it for sort of online courses, things that they've been meaning to get around to but haven't. And then lastly, you can refer to the ability to volunteer. So people can volunteer for other organisations. This isn't a way of saying, well, you're not working for me, but actually you're doing voluntary work for me. That's not allowed. But for somebody else, volunteer for somebody else. And I'm aware that I think the local government has been writing to employers to actively encourage them to say, to your furloughed staff, perhaps you can help out in the sort of COVID-19 effort, volunteering effort out there. So I'm going to move on then to consultation, selection, rotation and return to work. I've managed to get my notes slightly out of sync. Okay, so consultation. So for those without a layoff clause in their contract, to get them to accept 80% of wages rather than 100% is a change. If they agree it, then the consultation requirements are probably okay. If they're not agreeing, then enforcing it could kickstart the obligation to consult with them. If you have are looking to change the contracts of 20 or more, then the collective redundancy consultation regulations are likely to apply. Actually, what happened, everything was in the, for the people that are furloughed in the initial few weeks, there were probably very little of that done, if any of that done. And as most employers will have already furloughed their staff, then it's probably academic now, but I'm just hoping that there's not going to be, the sort of ambulance chasers, employee claimant lawyers that will pick up on this later. Selection, similarly, there's an argument that probably most of you have already done that selection, but I also think that what I'm going to say in relation to selection is relevant to the return to work. So in relation to both is that the same principles apply under existing employment law, so things like discrimination, protection, unfair dismissal. So for discrimination, for example, if you furloughed all of the men, then that's, you've done that on the grounds of sex, so that's not going to be allowed. If you furloughed all the Scottish people, that's clear discrimination. Now, I have no doubt that none of you have done any of that. But there is possible arguments where, and indeed discrimination law is a day's course on its own, but there may be areas. So for example, if you have furloughed all those with health conditions, that would be certainly direct discrimination, or arguably claimed as discrimination, but it could well be, and to me it would seem that you would have objective justification for doing that. So your health and safety concerns about those individuals and about the rest of the workforce. If you perhaps furloughed your older staff, you can see that age discrimination could come into that. The government guidance about the protection talked about people aged over 70s should consider themselves extra vulnerable. So I think you'd probably be objectively justified in picking your over 70s, but probably anything less than that is again sort of possibly open to a claim. But again, for the people that have already been selected, these principles will have sort of passed now, but it's also to bear in mind when you're bringing people back. So if you don't need everybody back, but you need some people back, then have a think about how you're going to choose those people. I think the simplest way is simply to ask for volunteers. If you ask for volunteers and you get more than what you need, then maybe you pick them out of a hat. If you get less than what you need, you're still going to have to do some sort of selection criteria, but at least you've started. Because it's surprising, some people that want to be furloughed, I would think a lot of people want to be furloughed, but equally some people don't want to be furloughed, and that's the problem in this discrimination thing, is people could be arguing claims on whether they did want to be furloughed or whether they didn't want to be furloughed. So volunteers certainly helps with that. Or if not, like I say, when you're looking to return to work, then maybe consider some sort of matrix, or just be confident that how you've arrived at the people that you've arrived at, and that you can speak to that, so keep a note of it. I wanted to say very briefly about health and safety. So when you've got people returning to work, they might be concerned about the safety of the workplace. You may already have done COVID-19 risk assessments if you've kept the workplace open. Again, because of everything that went on in those first few weeks, you would be probably in the majority of not having done a COVID-19 risk assessment, but now time's sort of a little bit further on. I would certainly be recommending that those be taken up with whoever does your health and safety. And it may be that then when people come back, or you want people back and they're objecting to it, you can point to your sort of health and safety risk assessment. And I know that there is an occupational health providers out there that can also, offer a service whereby they'll speak to individual employees that are concerned to try and alleviate their concerns about coming back. Okay, so I'm very conscious of time. So what if we still need to make redundancies? So the redundancy law is still going to apply for anyone who's got more than 2 years service. That includes bringing a claim for unfair dismissal. So redundancy is potentially a fair reason for dismissal, but the employment law provides that you still need to jump through a few hurdles. It includes how you select that individual. That should be sort of transparent, and the selection process undertaken. There should be a consultation period with them. So all of that law still applies. But the specific thing I wanted to mention was about the interaction with furlough. So if you do making redundancies, you've had your consultation period, you've selected the individuals, they are then entitled to their notice pay, which is whatever their contract says, or statutory minimum notice, which is 1 week per year of service, plus a separate statutory redundancy pay, plus whatever holidays accrued. So the furlough scheme is not going to cover statutory redundancy pay, and it's not going to cover the holiday accrual. There has been some discussion about whether you could use the furlough scheme weeks to cover part of that notice period. My view is that the answer is no. I think you can use the furlough period to consult with them. So if, for example, you had more than 100 employees and you're supposed to, who are going to be affected, and you need to consult with them for 45 days, then you could use the 45 days within the furlough period. When it actually comes to the point of issuing them notice, though, then I don't think that can be claimed under the scheme currently. However, because you're going to have to pay notice anyway, you may choose to issue the notice still with it and still make a claim if any part of that is before the 30th of June within the furlough scheme, and see what happens, because you're going to have to pay that money anyway. So it would be it would be a bonus, I suppose, if you could use the furlough period. But actually, my current views, and this may change, that's the thing with all of this, is that it can change from sort of week to week as we sort of analyse the different sort of ways of doing it and more guidance comes out, is that I would be quite comfortable with you using the consulting about redundancy during the furlough period, but I would not be comfortable about guaranteeing that you'll be able to use some furlough money to cover that notice period. Okay, so I hope that all sort of flowed. Thank you all. I'm going to pass back to Sarah to.
If you want to leave that on the screen, Karen, we'll carry on with it like that to save a little bit of time. So just very whistle-stop tour through some final sections here. So in terms of holiday accrual, so whilst people are on furlough leave, they are still accruing holiday. And so that's something that is really important to take into account in your calculations. Now, there is an option now to carry forward holiday into the next 2 leave years. However, that is still potentially going to cause you some challenges further on down the line. So now is the time to start really thinking through how that can pan out. If people take holidays during a furlough period, they need to be paid at 100%. So you can still claim the 80% bit up to the £2,500, but actually they're entitled to receive the full 100% pay for that time off. What I would suggest as well is looking at whether people have booked a holiday prior and it's already there, and whether they still want to use that time or not. They're yet to confirm in the guidance, and this is something that we're working with a lot. They're yet to confirm whether we can still enforce holiday, sort of like a shutdown period. We know that people aren't entitled to take holiday when they're on maternity leave, for example. They still accrue it, and you can't do anything with that time. But we think that this is quite different from maternity leave in that everybody's off, so it's not discriminating against any particular group of people. But that's something that you need to really bear in mind, because if you have furloughed certain people and certain populations of your business, will it be seen as discrimination for those particular people? Also bear in mind, if you are looking to enforce holidays, that you do need to give at least double the notice of the leave itself. So if you're asking people to take a week off, then make sure you give them 2 weeks notice before you do so, and then again pay it at the 100%. Okay, move on to the next slide, please, Karen. Thank you. So it all happened a bit quick, didn't it? One day we were all in work and everything was all hunky-dory, and we were just starting to hear a bit on the news, and it was all happening everywhere else. And the next minute it was, right, we're locking down, everyone's working from home if they can. People grabbed laptops and company equipment and information and all sorts of things. And actually, I'm not sure that all of us will have taken stock of what's gone from our businesses and how things are being used and stored. If anyone's else's home is anything like mine, you've got kids running around and all the rest of it, probably. If you're not used to working from home, obviously I am, but if you're not, then you may not have lockable cupboards and things like that. So it's thinking through, how are people storing this information and what have they got? And I guess what we want to try and get across today is to give you that permission to go back and check, just ask people. It's really not a problem to ask people, but you want to be able to sleep at night. You want to know what people have got. You want to know how, you want to be able to be clear about how they're going to use that information and where it's going to be kept. So if you've got any concerns around that, then obviously talk to us and we can help you where we can. Next slide, if that's all right, please, Karen. Thank you ever so much. Okay, and then just talking about absence and entitlements, and I know we've had a question from Rosemary that's already come up around whether people that have been told to self-isolate can be furloughed. Yes is the answer to that. So if the company is quite comfortable to furlough and they meet the eligibility criteria and things like that, then that is what this fund has been set up for. Essentially, it is there to help people that are impacted by coronavirus. And unfortunately, if you are asked to shield for 12 weeks, that is likely to impact your ability to be able to go to work and therefore earn money. And so furloughing is an option for you, but you don't have to be forced into it. As a business, as an employer, you can make that decision yourself. And getting views from people like occupational health can be helpful as well, to sense check that the person does definitely need to shield and that you've got all the information that you need to make that decision. Make sure that the eligibility criteria is met. Think about whether people need to be paid statutory sick pay, whether you've got company sick pay entitlements. Remember, we've set up this day one coronavirus statutory sick pay scheme now, so they don't have to wait for quite so much of that time to get them money. But also just listen to people a little bit. They're going to be worried at this moment in time. They're going to be worried at home, whether they're working from home. They're going to be worried about their family and their friends. They're potentially going to be worried about coming into work. So the biggest thing that you need to do at the minute is just listen to what they've got to say. That doesn't mean you've got to agree with what they've got to say, but let them be heard. Let them just say what's on their minds, and let them feel heard. And that way they're more likely to be much more engaged with you, which moves on to my final slide, which is much more around engagement, which is the topic that I love to talk about, because for me engagement is quite key. And coming out of all of this, those businesses that spend the time keeping in touch with their people are the ones that are going to be most successful going forward. And the reason for that is that the people will want to return to work to you. They'll want to work really hard for you. They are likely to be better prepared to return because they might have slightly more information about the business and what your plans are going forward and how you're going to come back from all of this. They're going to be working better as a team because they'll have spent some time doing different activities together and keeping those relationships going. So I've put down quite a number of different options there. But one of the biggest things I would say is, again, talk to your people. You know them, but you don't necessarily know them in this environment. When I look at my husband and my husband being somebody that absolutely loves to be by himself, most of the time he's quite enjoying this. For me, I'm somebody that likes to be sociable, so this doesn't work for me in the same way. So you're going to have lots of people within your business with different styles. So just have a bit of a think about what might suit different people. So a quiz might absolutely be great, and some team activities for some people, but some people may just not want to join in. Don't feel bad that they don't want to join in. That's just their nature in itself. But have a little bit of think about what might they like, even if that's just email contact or picking up the phone just on a one-to-one basis or something. Don't feel like you've got to do the same thing for everybody. It is about preferences. Okay, so we've come to the end of our presentation now, and I think I've covered off Rosemary's question there, and I've also noted down Matthew's at the beginning. So Matthew, you were talking about splitting furlough periods across the payroll months. Karen, have you got a little bit of guidance around that? Can you help at all?
So I'm just picking up the question and answers now. Is there anyone? You can definitely split. You could make a claim once every, well, all the guidance talks about once every 3 weeks. I've just had listened to a seminar from an accountant that was filmed yesterday, and there was lots of accountants on the forum where they were sort of talking about their experience of the portal, and he said a month. So that he said that you could only submit a claim every month. So that's what's made me slightly reticent. But speaking to my payroll bureau that I get my advice from, they've said it once every 3 weeks. But yes, you can cover across different months. There's been a couple of issues I think that people have been asking about on this, or the accountants were talking about, in that, so because you can only make once a month, for example, if you've got part of March to claim for and April to claim for, then you should claim for all of them now, rather than sort of wait, claim for March now and claim for the rest of April in 2 weeks' time. They've also said that the portal doesn't, it makes it difficult if you've furloughed people on different dates. So for example, if you started somebody on, say, the 23rd and then somebody else on the 28th of March, so they've got different furlough periods, that the portal doesn't really cover for that. But what this accountant was saying is that you would just still only claim for the right amount, but still put it through from the sort of earliest date to the last date. Your payroll, I'm so thankful that I'm not on the payroll front. I would speak to your payroll advisor about that. But yeah, the starting point is it doesn't have to be 4 months that you claim for, but you just subject to the caveat that you can only make one claim either every 3 weeks or every month, depending on who was right on this course yesterday.
Brilliant. We've got 3 questions that are all very similar now. So we've got one from Darren, Wayne and Katie. You've all asked around holidays, which we've probably covered in a little bit, but I'll just make sure that we're really clear on that. So the questions are, can you ask people to take holiday while on furlough leave? Can we allow people to take the bank holidays or carry them over, and what do we have to pay them? So in terms of holidays, as we've said, they need to be paid at 100% if you're making those payments. If you want to ask them to have more time off, then you can, although the guidance isn't very clear on that in terms of whether you can enforce it. So again, just making sure that you're really clear on the level of risk, I guess, that you want to take. But there's just making sure that you give people plenty of notice if you are doing that. And we often say double the holiday period itself. In terms of notice to give. The question from Wayne, you're saying, can we carry forward those days? You shouldn't need to, so you can just pay the additional 20% on those bank holidays to mean that you that then means that they've utilised that accrued holiday. If you want to carry it over, then that's no problem. I'm quite sure the employees will be thrilled that you're giving them some extra days off further on down the line, but I think that might come costly to you as a business, and I think most businesses would just pay the additional 20%. Having said that, obviously if it's capped at the 2,500, that might be a bit more money of the that you need to pay out. So it's again balancing all the books and funds at the minute. Have you read John's there, Karen, at all?
I sent original furlough. So the question was, I sent original furlough letters on the 23rd of March to 14 employees, but when the lockdown was extended last week, I only sent text to advise that the furlough had been extended. Should I also send letters again? If you're extending it week by week, you could either send a letter each time, or maybe at the last, you could do something at the end, sort of something that captures at the end. So for example, if you're extending it week by week, and at the end of by the text, and then at the end of week 3 you think that you're going to get them back at the end of that week, you could say, you know, just do a letter then to effectively confirm that the period's been extended and when it was going to end. Or you could equally send a letter each time you're doing it. I don't think it matters really either way, but it would be nice to have something that you can point to at the end of it that showed, if you're asked, you know, what the length of that particular individual's furlough period was.
I think it also probably depends on what you said in your original letter, as to whether there was an option to extend it and things, and how it was positioned in terms of how that would be communicated. Because if the letter, for example, said you were going to write out, then absolutely you need to be doing what you've agreed on that letter. But likewise, if it is that there was nothing that sort of spelled that out, then you know, that bit of flexibility probably isn't so much of a problem. Okay, AJ, so if I furlough myself for 3 weeks, work for 2 days, and then furlough again for 3 weeks, do I calculate normal salary by dividing by the total days in the month and multiply by the number of days worked? And what about weekends? This is quite a specific payroll question. Karen, have you got your head around that in that time?
So on Friday, they issued some more guidance, because the portal was coming live on Monday. They issued a specific separate guidance about how to work out your 80%, and everybody just thought you would be working your 80% on the very common sense based on working days. The guidance that they issued on this Friday night talks about calendar days, and having been on this webinar with this accountant yesterday, it is just causing an absolute mess. So they were actually running a poll live on this sort of webinar of whether the accountant was still just putting it through as they were working out the entitlement based on working days or calendar days. And the majority was still doing it on working days rather than calendar days, on the basis that they thought that it will get changed in the future. So strictly, I mean, there is an online part of that guidance includes an online calculator that you're supposed to be able to go in and like say what you want to do, and it will calculate it for you. So that only went live yesterday. However, when they're given examples in this guidance on the Friday, a few of sort of nerdy accountants run through the government's own examples into the online calculator on Monday and got a different result based on what the guidance had said on the Friday. So they took the online calculator off because it was clearly not working. I've quickly gone on just before this seminar and seen that online calculator is back on. Whether or not it's working or not, I think the actual process now of working out that 80% has been turned into a bit of a mess. I spoke to a payroll bureau today, actually just before this call, to have a conversation with her about it. And what she said to me is that because obviously she's the one that's sort of looking at it all, let me find it. The calculation for part salary should be based on calendar days, but does include this statement: HMRC will not decline or seek repayment of any grant based solely on the particular choice of pay calculation, as long as a reasonable choice of approach is made. She said that I'm happy that all previous calculations based on the actual working days and working pattern were reasonable. The best I can say.
Thank you, Karen. Okay, Claire, you've mentioned about can you furlough someone on maternity leave? So I guess to a degree it's depending on where in the maternity leave they are, but for the majority of cases you would just carry on as a maternity case rather than furloughing. If they were about to return to work, then you could potentially be looking to furlough them at that stage, but it would very much depend on the individual circumstances and the position of their role on return and the level of risk and care and all of those kind of things that would come into it as to whether that would be appropriate. So hopefully that answers that close enough. Michelle's was around a calculation again. So if someone was off sick for all of February and on statutory sick pay, is the 80% claim based on their statutory sick pay? My answer to that would be no, it would be based on their normal salary, not their statutory sick pay. But I'm just going to look at Karen just to sense check that.
Yeah, so if they're salaried and they're on a fixed salary, then it will be whatever their salary was as of in the last pay period prior to the 19th of March. So whatever their full salary would have been, so not the SSP. It gets slightly little bit more complicated then for people who have variable pay, because the variable pay calculation is either whatever they were paid in, let's say we're looking at March, whatever they were paid in March 2019. So presumably they weren't off sick at that point, so it would be whatever was paid then, or it was an average of what, if higher, an average of what they were paid in that tax year. So that February, you know, the SSP in February would have been part of that tax year, but you've got to work out that average. So it will depend on whether it's a fixed salary or whether it's the variable pay, and the SSP might, like I say, affect that average payment. But assuming they still worked for you a year ago, then I would think that that will be the higher amount what they earned last month.
Okay, thank you, Karen. Muna, unfortunately, I'm not sure that we're clear on your question. We've just got a part question. Hi, I manufacture uniform at the moment. If you want to drop another question on there, then we'll get into that in a little bit more detail. Matthew, you've raised the query about the liability for wanting to pull someone back prior to the 3 weeks being completed, which I know is a situation that Karen's actually been having and dealing with, where people furloughed quite quickly and then have felt the need to bring people back in. Unfortunately, the furlough period does need to be a full 3 weeks to be able to claim it, and so the company themselves will be liable for that payment. Now, depending on how you agreed that in the beginning, and whether you could potentially look to do layoff instead, that might be an option if it's within the contract and that was agreed at the start. But again, that would probably be based more on individual circumstances to talk through that particular query. If you've got anything else to add there, Karen.
Yeah, I had a few clients in that position and they've just all paid the back pay. But yeah, if you really wanted to try and get out of, like as in they paid the full back pay, if you really wanted to try and reduce that liability, then yeah, would need to look at the individual documents that were issued to them at the time.
Okay. AJ is telling us that the online calculator isn't currently working for a regular payment, so it doesn't seem to be ready yet. I can't say that I'm particularly surprised. I do feel for them a little bit. They're rushing all this, aren't they? So I guess bear with them a little bit and see what comes out over the next few days or so, and the updates that they can probably make to it. But likewise, from what Karen said, we're just looking at what's reasonable and appropriate, and as long as I think people not taking too much advantage, hopefully most of those things will go through. Diane is the next one. I tried the calculator yesterday and one of the questions was so unclear I could tell by looking that it was wrong. In view of the problem with it, what can you do if you make a claim but the amount is wrong? I think, as we've said, Diane, it's very much about just what's a reasonable in the circumstances, and doing best calculations, keeping evidence of why you've chosen the calculations that you have, and the considerations is always useful, because we're likely to forget in potentially 12 months time when the HMRC customs come and knock on our door. But yeah, I would just go with the best and the most appropriate. There's a lot of payroll businesses that are looking at this in a lot of detail. I particularly use the back office as a particular one, just because I know they look at things correctly. But there are lots of companies out there that can help you if this isn't your area of expertise. It's not my area of expertise in terms of the calculations either. So that's why I would always go to someone that knows what they're doing.
What I would say is there is a difference. There is a difference between what you are, or there could be a difference. I know we don't want there to be a difference, but if you have said to your employees that you will pay them 80% of theirs and told them how, use the guidance and told them what you will pay them, that is what you should be paying them. Whether that is then exactly how the HMRC calculate it out, then clearly we want the two to match, and that's why we're all hoping it changes back from calendar days back to working days, I think, because then they would match. But if they don't match, then what you can reclaim back, unless you specifically put in your agreement, I'm only paying you exactly what I can get back from the scheme, which you might have done. I think there might be some agreements out there like that, but most letters or agreements will have said we will pay you 80% of your salary based on this, based on this method. And to me, that's what you should be paying. and then the argument with HMRC as to how they are calculating it, if different, is separate to what you've said to your employees you will pay them.
Thank you, Karen. I'm not certain of the answer to this, so I'm going to look at Karen for it. But I submitted 2 separate claims yesterday on the portal, one for last week of March and one for the complete month of April. Oh, sorry, the question's just gone. And the question was around whether I guess it will be declined if you've put too much through, that there was only 1 claim allowed at a time. Karen, have you heard?
Certainly my understanding was that you could only make 1 claim at a time, and that's what these accountants were talking about on this webinar yesterday. But that isn't to say that if the portals are going to allow you to make 2 claims, then great. The answer, unfortunately, to that is I just don't know whether it's going to pick it up on a later time that you couldn't have made it for that. I don't know. But if you've tried it, you've done it, you are where you are. Let's see what happens. It won't, if it doesn't get captured on this one, it doesn't mean you would then just include it on your next claim, what wasn't captured, what didn't go through on this one. So it's not like because you haven't claimed it for April in April, that means you're not able to claim it at all. As long as you claim it within however long the portal is open for, which is going to be at least the 30th of June, but it's fully expected to be longer than that, as long as you can pick up these amounts.
Okay, I've got 3 more questions left at the minute. So in response to the last question, if someone was off sick, they can still be furloughed on 80% usual pay. So again, I suppose it depends on why they're off sick, would be my first question. Just helping us to understand, is that a coronavirus related sickness? If it's a coronavirus related sickness and it's a short-term sickness, the guidance talks about statutory sick pay initially. If they're on long-term sick, furloughing can be used. Is something that's available, and again, reading the guidance and making sure that we're really clear on that. So I guess it comes down to a degree the individual circumstances of that person and why they're off sick, and whether they should be furloughed or not, as there are other people within the business being furloughed, people within that role being furloughed, etc. To be really certain on that. Have you got anything else you wanted to add there, Karen?
Yeah, so the guidance sort of kept changing, but it kept getting more generous to people that are. It started saying if you're on SSP, then you would only be furloughed once you'd stopped the SSP. So, for example, if you submitted a sick note for say 2 weeks or 3 weeks, and then you probably could qualify for it. Well, you would qualify for a sick note after that. You could nevertheless be furloughed for that period, as long as that furlough period was at least 3 weeks. And the guidance actually still, and then the guidance changed about sort of 10 days ago to say that actually you could, even if you were entitled to SSP, you could change that, as long as you didn't claim for SSP and then furlough period, that employee could be transferred to furlough rather than SSP. So, for example, if you'd had somebody that in that instance had 3 weeks SSP, and then perhaps submitted another sick note for 2 months, that you could, rather than use the 2 months and put them on SSP, that you could furlough them. So that's where we all thought we were. Now the Treasury direction that come out on Wednesday says that you can only furlough somebody after their initial period of SSP entitlement runs out. So I've actually got somebody that they didn't get the letter to Shield, even though it was very clear they should have got the letter to Shield. In a bit of a sort of panic about it, they went to their doctor. Their doctor gave them a sick line for 12 weeks, not 12 months. So they've put that into the employer. The employer's paid the SSP for the remaining period of March, but now they want to furlough them. Well, if you following the Treasury direction, because that original sick note was for the 12 weeks, it seems like you can't furlough them until that sick note runs out. So rather than them having, let's say, in 12 weeks' time, they've still got to Shield, rather than getting a sick note, you can furlough them at that point. But that's not what the guidance says, and it's difficult. I think on the agreement one, I'm a bit more comfortable sort of saying, well, even though the Treasury direction does really trump the guidance, just because of how it is, I think we can manage without the agreement. On this SSP one, I'm not so comfortable saying that. I think at the moment we've got to work with the Treasury direction that says the first period of SSP entitlement needs to have expired before you could furlough them. So I'm hoping in that particular instance that the question you've asked about, they've maybe put in a sick note for 3 weeks, that they're just going to be, you know, furlough shouldn't be used for somebody that's just self-isolating for 2 weeks or something like that. That's been quite clear. We're now sort of talking about people that are, you know, on sick leave for a longer period of time. So if somebody's submitted a sick note maybe for 3 weeks, then they get the SSP for the 3 weeks, but then rather than submit a sick note for the remaining period, the employer could agree to furlough them. So a difficult one, I'm afraid.
Thank you, Karen. I think that's it. All down to interpretation, isn't it? Okay, last 2 questions. So we've got Darren. How long would you suggest keeping staff levels on rotation between office and home when they return, so you don't have all in at the same time and potentially have to isolate them all if someone shows symptoms? And how would it be fair to split them? So I guess it depends on the type of business that you run and the space that you've got. That I think would be something I would want to talk to a client about directly, to understand what they're trying to achieve. So do people actually need to be in the office at all? Can everybody work from home? Would be my first question, because even just traveling in and out of work, part of what we're trying to achieve by the stay-at-home thing is obviously around managing the risk of the NHS, and obviously every time we go on the road there's a risk of accident, and so by staying at home, that is the first option always. If it is that you need somebody in the office for whatever reason, I guess the health and safety side of me comes into it in terms of you don't want people by themselves in the office, but you also need to bear in mind the medical side of it as well, in terms of the transference of the virus. What are they touching on the way into the office and things like that? So you may want to get an occupational health review on it, or do some sort of risk assessment through health and safety companies to just understand the implications of it. But I think the first point is very much what was the benefit of them actually being in the office and leaving their home would be the first thing. And finally, Natalie, if someone's hours have been reduced, can they now not be allowed to be fully furloughed, i.e. reduced to 3 days a week, now look to furlough them from the new wage? Karen, did you want to cover that one off?
So if someone's hours have been reduced, can they now not be allowed? Okay, so my understanding is that you've had somebody who has worked a 5-day week, and then at the start of the coronavirus situation, so let's assume that was sort of in March, you've maybe agreed to put them down to a 3 days week. Now, I definitely want to see whatever variation, you know, whether you got a variation letter agreed on that, or whether it was always a temporary basis. But now, as I understand it, you don't want the 3 days a week, you just want to furlough them completely. And you're asking whether you would furlough them based on the 80% of the 3 days a week, or it would be so if they're have a fixed salary, then it's you can claim for 80% of what they were paid in the last payroll that predated the 19th of March. So if they were on their 5-day working week at that point, then you could pay them. You could calculate the 80% based on that amount. If that 3-day a week was like a permanent variation, and at the end of this, you don't want them to come back on, you won't want them to come back 5 days, and you want them to be 3 days going forward, then that's sort of a question that will depend on what documentation you issued to them at the time. But in terms of the question about what you could claim from furlough, I would say if they were on the 5-day a week in the payroll before the 19th of March, then you could claim 80% of the 5-day a week. So I hope that helps. So I'd take specific advice on whatever was issued to them at that time.
Brilliant. I think that's everyone's questions answered, and I think we've covered all the topics that we're aiming to. So hopefully everybody's enjoyed the session today, and I'll pass back over to Laura, I'm sure, who will finish everything off.
Fantastic. Wonderful, guys. That was really, really good. So thank you so much for coming along today and giving all that really important information out to our members. Really appreciate it. Just for the attendees today, just so you know, you can get a copy of this on our webinar library. So as of tomorrow, this will be recorded and you will be able to play this back. Should you have missed the first bit, or if there's bits that you want to go over, you'll be able to do that as well. We do host webinars every day, pretty much at 2 p.m. now, and we are starting to host some webinars at 10 a.m. as well, just because we're getting so busy. So please see the Staffordshire Chambers of Commerce website, and we should be able to help you with the webinars. And for now, that's it from both myself, Sarah and Karen, and we look forward to seeing you very, very soon.
Thanks, everyone.
Thank you.